May it please the court. I come here today a humble pro se before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
I generated that.
I'm sorry?
I generated that. That is not a real person.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application. And you have appeared before this court and been able to testify verbally in the past. You have gone to my clerk's office and held verbal conversations with our staff for over 30 minutes. Okay? I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't. You are not going to use this courtroom as a launch for your business, sir. So if you are able to shut that off.
You know, one thing we might seek down the road is an itemization of exactly how this child support is being spent, this $5,392 per month.
Dr. Kroll makes probably at least 4 times as much as my client. I'll just go through, for example, a list of expenses for these children that my client has borne the sole responsibility for.
It's been tough. You know, Chris doesn't help with any support for anything extra on top of the child support. And yeah.
Dr. Kroll has recently purchased $1 million house. My client recently had to sell the marital home that she was awarded so that she can support these children.
We have beliefs that this entire litigation is a attempt to increase the child support obligation. Dr. Kroll was paying an agreed upon amount of $5,000 per month, and that's an upward deviation of about $1,600. This increases for child care costs. The plaintiff works from home. The children are 10 and 12 years old. The 12-year-old is old enough to babysit other children, and in fact does babysit other children. And when she's doing that, she's not even attending or present for this childcare that they're requesting. Dr. Kroll has people who are available to provide childcare to these minor children if it's needed.
My client is only utilizing the nanny 3 days per week. She's employed full-time with Blue Cross Blue Shield. She has an extremely demanding job. She works 5 days a week, but is presently only utilizing the child care 3 days a week due to Dr. Kroll's refusal to contribute to any of the costs. The right of first refusal provision that was referenced does not apply because Dr. Kroll is also employed full-time and is not able to provide care during the work week. There's nothing in the judgment or the deviation language that states that my client would bear the sole burden of childcare expenses and support, frankly, the cost of this litigation.
What about this offer of free childcare?
I believe that what they're referencing is Dr. Kroll's offer to have his mother care for the children. My understanding is while the parties were married, they historically did not use his mother to provide summer child care because she would charge them.
Allegations as far as not contributing to some of these expenses, it's not entirely accurate. Quite frankly, that's the purpose of the upwards deviation of the $5,000. It was intended to include all of those things that they're complaining about.
These parties have been separated for 2 weeks. Some of the allegations that he makes in his motion allude to the fact that she doesn't have a job. Your Honor, she's been a stay-at-home mom for 5 years. She has been the sole provider for this minor child. To penalize her for being a stay-at-home mom and not having enough time to find a job would be unjust and would be against the best interest of the minor child. To say that she is detached from the child as alleged in the motion is a complete blatant lie. She has tried to get her child back from defendant. Defendant will not release the child to her. He's only allowing her to see the child if she comes to his house, where he also tries to initiate romantic involvement with her, which she has distinctly objected to.
Let's address some of the allegations. Ms. Thomas has stated that She turned the child over to the plaintiff and said that it was best that the child would be in his care, apparently because she had acknowledged she had some suicidal thoughts and acknowledged that she was being evicted as well. So speak to those allegations.
My understanding of the situation is that the parties were living rent-free in an apartment provided by the plaintiff's work. When they split 2 weeks ago, he went to the office and told them that she needed to be removed.
He left the home with the child. She knew that. As far as her being a stay-at-home mom, she did not work because she used the child as her buffer to not work. But again, he had to come home regularly during the daytime because that she wasn't really able to do it by herself. As to the eviction situation, that apartment, he worked at the complex where they resided, and that because of her having a relationship with a neighbor, the apartment complex didn't want to have there be any repercussions from any of the residents. So they helped him get a job at another apartment complex in the same company. So because of that, that apartment is no longer going to be a free apartment. Because she was also residing there, they did do a 30-day notice. He's not got an apartment. He's not working at that location. There's no apartment to go with his job anymore because he's not at that job. It's not like he tried to get her kicked out. That wasn't even how that happened. They said, well, as long as there's a potential issue with the neighbor, we're going to help you get.
Sneaky ex-wife tried to scam both her husband and the court. She thought she had it all figured out until the judge exposed her scheme instantly.
You filed a complaint for divorce in this matter in November of 2024, correct? And all the allegations in it were true and accurate when you filed it, to the best of your knowledge?
Yes.
And you presented to this court a judgment of divorce that you believe to be a fair and equitable division of your marital assets, debts, and all issues of your marriage.
Yes.
All right, Tony, did you hear that testimony?
I did.
True and accurate, sir?
To the best of my knowledge, yes.
That's all we can do is to the best of our knowledge. This court has jurisdiction, and the proofs are sufficient under the document. So we'll be getting this processed. There is a 21-day appeal period on it. After that three weeks has elapsed, we'll be sending you the copies, Sherry, and it'll be your responsibility to send Tony his copies, okay? Good luck to both of you. Have a good weekend.
Thank you.
I have a question.
Sure.
Regarding the split of the assets, how does this work and how should we proceed?
You proceed in accordance with the judgment and how everything was split in the judgment.
I have not seen, nor have I been given any information on this whatsoever.
Miss Toe, did you not send him a copy of the judgment?
When I turned in my motion to enter default, they took all 3 copies.
You did not send him a copy?
No, they took it from me and said the judge had to sign it.
Then I cannot sign this. He gets to see this 14 days prior to my signing it. Ma'am, the copies are for the court copies. You still have to send a copy to him.
They took all those copies from me as well. I gave them to the clerk and I said I need to send him one.
It's your responsibility to send him his copies. So the judgment cannot be entered at this time. He has 14 days to object to it. Okay.
Yeah, because I have no idea what the division of property is. Nothing has been
understood.
Communicated to me whatsoever.
Like I said, the law is very clear. You're supposed to be given a copy of it 14 days before the hearing.
We talked about motive versus intent. Motive is not what needs to be established. There are counts for which the intent of the defendants needs to be established. In principles to a crime, did the defendant help another person?
Take him.
Somebody shot me and somebody shot that. It's simple as that. Oh, pick this thing down. Somebody knew that shit gonna happen. Somebody shot. I feel sorry for that little girl, but somebody shot. Look, it's the truth. Y'all can be quiet.
All right, ladies and gentlemen, the court's going to take about a 10-minute recess while we take care of some obvious issues. We'll be back when we can.
All rise for the jurors.